All right, welcome everybody. Today is April 29th, and today we're talking with Jeanne Hannah. I know you can't see Jeanne on the screen yet. She's having some technical difficulties, as I mentioned a little bit earlier, and we're working on getting her on the line. And you're doing that, Jeanne, I'm going to introduce you. So I've been in Michigan for 17 years, and when I moved here, I feel like Jeanne was a pretty famous attorney already. If we went to family law conferences, Jeanne would be anywhere she went, she'd have like a crowd of people around her waiting to talk to her. And she was really well known for the very topic we're covering today. The flyer that you received mentioned three things. It mentioned UCCJ, UCAPA, and Hague Convention. Jeanne and I gave it some thought, and really all of those topics are too big for 1 hour by themselves, all together. So we made an executive decision today that we're going to cover the Hague Convention, and then we'll revisit the other topics at a future date. So if you came here for UCCGA, there's not going to be too much about that, although I think this will give you a good idea of how the Hague Convention is different than the UCCGA. Jeanne, do we have your audio working?
Yes, I have my audio working finally.
Oh,
yes.
Excellent. Good. Good. Okay. Well, welcome, Jeanne. So Jeanne has worked on cases all over the state, but she's worked on cases involving so many different countries. And she has some really great examples to share with us today that will help us when we have a Hague Convention case in our own cases. And so really the first question I wanted to ask Jeanne, as more of a backdrop for what we're doing and to help our audience understand the difference between Hague Convention and other international interstate custody disputes. When a potential client or a client walks in the attorney's door, how does the attorney even know which statutory scheme they should be looking at? Whether it's UCCJ, UCAPA, or Hague Convention. How does that attorney even figure out before they start calling attorneys for help, calling people like Jeanne Hannah, who is obviously considered an expert in the field for Michigan? How do they even figure out what their client is facing?
Well, it's going to be obvious. If they're coming in to recover an abducted child, the first question is, where do you think the child is? If the child is within the United States, then it's a UCCJEA case. If the child has been abducted to a foreign country, if the passports are missing, and parents typically know this kind of thing, that there have been some arguments, there have been some things going on, and they will tell me that. So that's when I decide that it's a Hague case or a UCCJEA case.
And you mentioned a child being abducted and taken away from the United States. I assume that the same concept applies if the child's abducted from another country and brought to the United States.
Exactly. Mm-hmm.
Okay.
That makes it really easy, because that's what they're coming in and saying. Mm-hmm.
And just to help the audience understand the difference between the two statutory schemes, what's the primary question that the court is asking or having to resolve in a UCCJ case versus in a Hague Convention case regarding the child?
If the potential client coming in is what we call the left behind parent, if the children are missing and that parent is seeking to recover the child or children, then and believes that the children have been taken to another country or haven't been returned after summer break, for example. Mm-hmm. The Hague Convention deals with wrongful takings. It deals with wrongful retentions. So we establish that. This is a really fact-intensive matter. And so it's the first thing that I do, it doesn't matter which of these bodies of law I'm using, first thing that I do is develop with the client's help an extremely detailed, blow-by-blow, chronological list of what has been going on. You know, when were the parties married? Where were they married? Where did they live after they were married? Where was the first child born? Interestingly, if I make a decision want to get all of the facts that I'm going to file for this left behind parent in the United States, if I'm going to file an action to recover the child, and I decide to file it in state court, which is one option, the other option being a federal court. In state court, we're expected to file a UCCJEA affidavit. So that's one thing, that I would start with, but it is often very difficult to get the facts that you need in great detail. Sometimes you have to work very closely with the parent. Sometimes you have to deal with things like English is not the parent's language of origin. So, I may decide that I have to have a translator. That occurred in Macomb County when I had to have a Japanese translator for everything because the mother did not speak English at all. As the facts are developed, they become part of what I want the trial court to decide are the findings of fact in the trial court's order. And so I'm going to be fashioning this very, very carefully.
We dive into the Hague Convention. One of the things just to point out for the audience is the difference of what the factual question that the court's going to have to answer regarding where the child lives. And under the UCCJA, just confirm for me, it's a home state question versus under the Hague Convention, it's a habitual residence question. And we're going to talk quite a bit more about what that habitual residence means. That's part of today's program. Jeanne, is there anything you want to say about home state jurisdiction under the UCCJA before we move to our deep dive into the Hague Convention?
Well, the UCCJEA will likely become important later if the court decides that the child was in fact removed from a foreign country, brought to the United States, but the bringing of the child to the United States was not wrongful, and proper subject matter jurisdiction to make a best interest test, to make a custody determination belongs to the state that has subject matter jurisdiction, or in the case of the Hague Convention, to the country that has subject matter jurisdiction. Let me give you an example, because I think that will make it more clear. I had a case a year or so ago where the parents weren't married. The child was born in England. The father's name was not on the acknowledgement of parentage that could have been signed in the hospital. Only the mother's name was on there. The father wasn't involved in the birth at all. Hadn't supported the mother for the last half of the pregnancy. She did, with a neutral supervisor, let the father see the child a couple of times. And, but again, no support, no real interest, late to the second meeting. And his idea of a meeting place was the bar at the Hilton. And so at any rate, she decided to leave England. The father then, upon learning from a friend that she had left for the States, he filed an action to establish his parentage. That's exactly what would happen here, you know, if he's not on the birth certificate.
Mhm.
But he took a long time to do that. When he did it, the first thing he asked for was a restraining order to keep her from crossing borders. Well, that, you know, the horse was out of the barn and she was already in the UK. But he still was quite slow. And it was a few months later that he finally got to the High Court of Justice in London. I had given her UK solicitor an affidavit saying this is what I would testify. The court asked me to testify by telephone, and I did so. The judge asked me some questions. He said, if this child, if custody, if jurisdiction is determined to be in Michigan, would the father have the right to seek custody? And I said, absolutely. Custody and parenting time. The child support issue is always determined where the payer is. And so, yes, he definitely would have the same option that he would have in the UK.
Well, I think you're bringing up an important point that the purpose of a decision under either the Hague Convention or probably even under the UCCJ is not to decide custody. It's to decide which court or which jurisdiction or which country gets to decide what happens to this child. And then we leave it to that county, state, country to then have their own custody case under their own laws and court rules, right?
Yes, Lisa, that's exactly right. And so the only question for the court is, does the other country have subject matter jurisdiction over custody, or does the United States have subject matter jurisdiction? And if so, what county? We know that would be the state and county where the child was found.
Was this the case where the child was born here?
No, the child was
Okay,
born
the child was born in England. Okay.
But the child left London before father established his parentage. In fact, about 6 weeks before, because he really didn't get busy doing that. And also, I discovered through my research that, in fact, the law in the UK is very similar to the law in Michigan. I would refer our audience here to the Acknowledgement of Parentage Act, MCL 722.1006, that law stating that if the mother, if the father has not acknowledged parentage, that the mother has sole custody. That's a very, in that case, it was the complete hot spot in the case.
Right.
So she had the legal right to determine where that child was going to live.
Now, you made an interesting comment earlier about state court versus federal court. And I think that you have some strategy considerations that you go through when deciding, you know, where am I going to file this case? Usually it's, I think you're talking about when you're filing on behalf of a left behind parent, right? They're the ones that have to get the filing started to have an opportunity to reunify with their child. So can you tell us a little bit about your strategy choices when deciding between state and federal court?
Yeah, I'd like to give you a couple of examples and tell you what factors went into my decision. I had one case coming in from British Columbia. It was a referral from the State Department Children's Issues Office, where I was then on the Hague Attorney Network. And I would encourage anybody who really loves this work so much as I do to become a member of the Hague Attorney Network. At any rate, after I talked at great length with the father and got all of the details I wanted about how, I mean,
Chronology.
Chronology is everything. And so I decided, okay, am I going to file in state court or federal court? In that case, the child was a teenager. And I elected for a very particular reason to bring it in federal court, because the mother, who was the taking parent, had in fact gotten her parents to put her up. And this is really, really common. Most mothers go to their parents or friends or somebody like that. And when they're at a parent's, it's easy to find them. But I learned from talking with the father what he knew, and that is that the parents were very well positioned in the county where they lived, so that it would not be a good idea to be in state court because of the perhaps pressure that they could bring to bear on the court, or maybe they knew the court. Some of them were police officers. It just didn't seem like the right place to go. So I elected to do it in federal court. I was lucky to draw Judge Janet Neff. She's an amazing woman, brilliant, and amazingly, she had never had a Hague case before. I make it a point when I begin a Hague case, no matter for whom, no matter what court, I provide the judge with materials that are provided by the State Department, by the office, Children's Issues Office, by various Hague resources to help them understand it. And one of them is a judge's guide. And it just explains the Hague Convention to the judge, and there are hyperlinks in there so the judge can easily maneuver around. The fact that she'd never had a Hague case did not scare her at all. She really studied up. She decided what needed to be done. Typically what happens is that when the case is filed, the judge will call a scheduling conference. The left behind parent, if in another country, will attend that by telephone or Zoom these days, or Skype, or, there are lots of different ways to do it. And then in the scheduling conference, it's determined what the judge wants to see in terms of who's going to file by what deadline, if there's going to be discovery, and what the deadline for that is, and when there will be a hearing. Now, under the Hague Convention, in black and white, it says that the case should be decided ideally within 6 weeks. Wow. I don't think I've ever finished a case in 6 weeks. And one of the reasons is this. Article 13 of the convention allows me to bring in, for my left behind parent, an enormous amount of documentary evidence. And under Article 13, I can put these into a notebook and call them exhibits or appendices. And those are admissible as a matter of right. No foundation has to be laid for them.
That's under the Hague Convention, right?
The Hague Convention.
Regardless of whether you're in state court or federal court.
Exactly. Okay. And that's very handy. In state court, under the UCCJEA, I might often need to have some kind of foundation laid for exactly like that. So I will have included in there a birth certificate, copies of passports, copies of school records showing where the child or children have been in school. In that case, I also had an affidavit from mom's best friend, who later turned out not to be mom's best friend, who said, I've known this family. My daughter has known this child, this 13-year-old girl, for 7 years. The parents lived in Vancouver for 3 years. Then dad got transferred to Denver. They moved all their furniture to Denver. And then we would go back and forth on vacations. Sometimes we'd go to Denver, sometimes they'd come to Vancouver, but we preserved this friendship. We had other means of communication. The girls never became anything other than best friends. The priest of their Catholic church drafted an affidavit in which he explained how long these people had been members of that church.
Mm-hmm.
The principal of the Catholic private school drafted an affidavit discussing her very great relationship, not only with her teachers and this girl, but also with her classmates. There was evidence about the neighbors and so on. Everything to make that substantial connection with that jurisdiction. That's the point.
So, I mean, it sounds very labor intensive on the backside of the case, right? When you're getting the case started before you even go to court. So tell us about how, with some examples that I know you have, about how all that work on the backside has resulted in a decision and a trial, or however it gets decided by the trial judge.
In almost every case in which I have used an Article 13 portfolio, there hasn't been much of a hearing because the judge has had a chance to look over these exhibits, and the exhibits show very clearly that this child is deeply invested in relationships, perhaps family, friends, neighbors, schoolmates, church, perhaps activities, medical things. I had one case in Eastern District, was actually my first case, and the child had a significant heart problem and had established a relationship in Ann Arbor with a medical team. So, you're looking for that kind of thing to put into the portfolio, into the Article 13. And that gives the judge a really good idea of, and I would draft a proposed findings of fact, proposed conclusions of law. I would submit it with that Article 13.
And you do that the same. Do you handle it the same way if you're in state court versus federal court?
I sure do. I sure do. And the reason is because it makes the court hearing so easy, and judges really appreciate that. Then I will file the petition. I have some form petitions that I obtained, and I'm going to give everybody here at this Zoom conference some things on the way out. For access to forms, other resources that will help them very much to decide how to approach the case, what are defenses, what are potential defenses, how can I eliminate the defenses, because it's not, the parent who is the petitioner has to build a prima facie case that it's a wrongful taking.
Okay, so I guess we should talk about what the court has to decide. What is habitual residence? So we haven't talked about that yet. We've been talking about like all the backside work, but I think, the audience, I think would be really beneficial for them to understand what habitual residence is and, the two tests that have been developed, because there's not a definition of habitual residence in the Hague Convention.
Right. There is no definition in the Hague Convention of habitual residence. And this has evolved since the early 90s when the convention evolved. Habitual residency is determined either by a test very much like the UCC-JEA test. What are the connections? What connection does this child have, or these children have, with this Hague jurisdiction, whether it's brought in state court or federal court, same test.
And you're referring to the acclimatization standard, I think?
I am referring to the acclimatization standard. Okay. And that applies mainly when you're talking about children who are older.
Mhm.
And Ahmed versus Ahmed, I believe
That was a case that went to the Sixth Circuit. A
Yes.
decision from the Sixth Circuit within the past couple years. We've had a lot of activity, just so the audience knows. In the past 2 years, it's been an amazing amount of appellate activity in our circuit, including a case that ended up in the United States Supreme Court, and we'll talk about that in a minute. But go ahead and tell them about Ahmed.
Okay, in Ahmed, the children were twin babies. And so the parents had been back and forth between wherever the mother lived, I think it was Georgia or someplace like that, and London. They had been married in London. She went back to the United States to finish her degree in optometry. Then she went back to the UK. She had several miscarriages. It was real frustrating for this couple because they were trying to have a family, but it wasn't happening. She finally came back to the US and started practicing, and she got pregnant with twins. Well, she got pregnant, yes. And then the husband talked her into going back to London. She was there. She found that the in-laws with whom they were living were very intrusive, and there was a lot of household strife. They ended up going to Bangladesh for a wedding, and whilst she was still pregnant, the plan was, husband thought the plan was she was going back to London with him. At the airport, she got on a plane for the United States, went to her parents' house. She had a very difficult pregnancy, nearly lost the babies, was several months in bed, trying to keep the pregnancy. The husband finally came over and took care of her, and then was, I don't think he was present at the birth, but he certainly did help take care of the twins after they got out of 3 months in the hospital. Then he thought that she would go back to London, and she said, "No, I'm not going back." So he filed using the central authority in the UK, claiming that the UK was habitual residence. But in fact, those babies had been born in the US.
But that was the case I was thinking about when I asked you that question earlier. Right,
Yeah.
and so the babies were born here.
And they had never lived in the UK. Mm-hmm. And so, of course, you're not going to have any acclimatization. And it's really going to end up being what court has a better grasp of what we would call a best interest test. Mm-hmm. You know, what court can make that determination? Most courts, unless you're talking about a Sharia court, most courts are going to make what we would call a best interest test.
Isn't part of the inquiry also like whatever court's going to have to decide custody, whatever court's going to ultimately decide the best interest of the children, where is that evidence going to be coming from? Is it going to be coming from England, where the children have never lived, or is it going to be coming from, I don't know if it was from Michigan, if the Ahmed case was from Michigan, but it was from the Sixth Circuit. So we have 4 states to pick from.
It was from Kentucky.
Kentucky, okay.
But the father is going to be asserting defenses, referring to the UK and trying to convince the judge that the UK has jurisdiction.
We're going to get to the defenses next. We're not quite there yet. Yeah. So everybody stay tuned.
The mother is going to, of course, build the case for the fact that the children have never been there.
So when you're talking about young children, as in the Ahmed case and other cases, oftentimes their newborns are very young children who the acclimatization standard really wouldn't apply. Then the other standard is called the shared intent standard. Is that right, Jeanne?
That's correct. And the Sixth Circuit, that was the theory brought by the mother in the case. That case was a long time in court.
You're talking about the Monaskey versus Taglieri case?
Oh, yes, it went
It started
to,
in 2015, and we just got the U.S. Supreme Court decision. So the kids are already 5 years old because the decision's
yeah.
from February 2020, but the
Mhm.
children were born, I think, in 2015.
That's correct. And so at any rate, not wanting to repeat the mistake made by the Friedrich Second Court,
Mhm.
where the child, where a stay was granted and the child was 5 years old when he was sent back to Germany. Imagine how strange that would have been for that child.
Mhm. Mhm.
Uh, the Ahmed case went first to the district court, then it went to the Sixth Circuit, then it was remanded to the district court, then it
Mhm.
went again to the Sixth
The
Circuit,
Sixth Circuit, and
and
then
then
en
it
banc.
en banc, and
It's
then
and that's a rare thing to have an en banc decision from a federal appellate court.
exactly.
Right.
The twins in Ahmed, in Monaschi versus Tagliari, the little girl was sent back to Italy 2 years into that 5-year case without her mother. Imagine that child developmental stage, and to be separated from the primary caregiver. That must be very traumatic for a child like that. In fact, it wasn't in the Ahmed case, but that it may have quoted Abbott versus Abbott, holding that child abduction is child abuse for that very reason.
Mhm.
So it was a kind of an odd thing. Mom was trying to get the shared intent. I never intended to live in Italy.
Well, her
However,
argument was that the parties, the husband and wife, did not have an actual agreement, and so, and her argument was that defeated a shared intent. So let's talk, if you want to talk a little bit about how
That's
the
right.
U.S. Supreme Court handled that issue.
Right. It's surprising how many of these cases in this Sixth Circuit area try to get the shared intent, and only the Sixth Circuit had not adopted the shared intent. It was all looking at it from the perspective of the child. Was the child acclimated or not? Was the child old enough to be acclimated?
Wait, are you saying the shared intent standard was actually created in a Sixth Circuit case?
Oh,
okay. I thought that I misunderstood you. Okay.
No, I'm not saying that.
Okay, I apologize.
At that point in time, I think there was still one circuit out there that didn't have shared intent in addition to the Sixth Circuit, but it was not the test.
Got it.
So the mother pushed for that and said, I never intended to live there. Well, when you go through the fact findings in that case, you can see that they did live apart for a period of time, but then when she got pregnant, she moved to the same town he was in, and then they eventually got an apartment there, and then he beat her up and she moved to a women's shelter, and he allegedly beat her up, sorry. and so then by the time they got to court, Mom was still arguing for I didn't mean to be here, but there was no signed agreement.
I didn't mean to be here, meaning referring to Italy?
Referring to
it. Yeah.
Mm-hmm. Mm-hmm.
So, so something you mentioned earlier, I just wanted to point out, you mentioned a lot of resources, and our intent, Jeanne and I have the intent of sending out some materials that are helpful to the people in the audience, to further you along when to your understanding when you come across these cases. But one thing I wanted to point out, and I bought this several years ago at Jeanne's recommendation, it's called, it's not showing up the screen. Okay, the Hague Abduction Convention. And it's by Jeremy Morley. I think it's an ABA publication. So, those ABA publications are not cheap, but it's a handy little book even if all you need is one case to justify having it. really, because it's such a complex area. And it goes into all this. Of course, the version I have does not include Manaski versus Tagliere because it was pre-2020. But they do update them, I think, every so often. This is a 2016 version. Oh.
Yes, I know Jeremy Morrow. In fact, he was the expert witness in a case that I did in, let's see, I did that one in Eastern District. I represented the mother who was alleged to be the taking parent. Now, I need to tell you that when I went into abduction, it was because of a passion that I developed because of what had happened to a friend of mine whose first child was abducted and didn't find her mother until she was 23. So that said, I have only twice represented an alleged taking mother. In both instances, I believe that a good and right and just decision was made, and that I made the decision based upon the facts of the case. One of those was this case involving the baby born in the UK, who was brought to Michigan when he was 3 months old, before the father had any parental rights. One of the things that is necessary for the left behind parent to establish, it's his burden of proof to establish that he had a legal right of custody. Well, he didn't. He did not establish that because he didn't have it.
So is that a precursor to the question about habitual residence? Do you have, the standing question is, do you even have a right to file, right? And you have to have custody of some nature. You could be married, right? A married person would have custody naturally, or
Right.
somebody with an affidavit of parentage or whatever the equivalent is. So that's one of the hurdles that the left behind parent would have to establish.
Exactly.
Yeah.
And because this mother had not only not had any financial support from the father for the last half of this very high-risk pregnancy, I was very inclined to help her. And it worked out just fine.
But you probably approach the case in a very similar way as you do when you represent the left behind parent. I'm guessing you did your chronology because that would show the, I guess, holes in the other side's case, right?
That's right. Also, the chronology would be, as I said earlier, the findings of fact and conclusions of law that I want the court to reach. Let me go back to that for a minute. I brought a case in state court in Cass County, Judge Herman and his staff. I cannot praise them enough. They did an absolutely wonderful job. The mother was living with her mother and grandmother 10 minutes from the Indiana border. So if she had had any idea that this case had been filed and was pending, and that the sheriff's department was going to come with a warrant to remove that child, she'd have been gone before they got there. There was a great deal of coordination with the court staff, especially the friend of the court's office and the sheriff's department office. I will often ask a judge to ask the sheriff to hold off on going to get the child until I can get my left behind parent in place, because it reduces the amount of trauma for those children or that child.
When you say in place, you mean the parents waiting for the child at like the sheriff's station or something, so they're ready to go as soon as.
In that case, the father was in Quebec, and so it was a 12-hour drive for him to get to Cassopolis. He got there on a Friday evening. He brought his mother to help him with the baby, and he checked in as we'd all worked out in kind of a committee form. I had a point person. I think it was the friend of the court's office. Anyway, so he checked in at midnight with the sheriff's department, and they said, come back at 9 o'clock. The warrant was extremely specific. Law enforcement does not like to get involved, particularly when there's no property interest of the parent in the house where that's going to be entered. There's a Fourth Amendment right to be the queen of your castle or the king of your castle. And so there's always been a great deal of reluctance, but the way I word my warrants, the law enforcement and the protective services worker who goes out to have the baby, because the policeman would prefer that, then they bring the baby back to the sheriff's department, and the reunion occurs there. And if there have been any allegations of, or if there's any question that there might be allegations of domestic violence from the mother, I find it quite normal that the protective services worker will go through an analysis and kind of a domestic violence protocol.
So I have a question about just using this Cass County example. Is this pickup happening before the judge has gone through the whole habitual residence findings, like as a temporary pickup measure? Or is this happening once the judge has already been, because otherwise they would know about it, right? So
this is very tricky because everything gets filed, and it is filed, but it's not put on the formal online docket, so that nobody knows but the court and the petitioner and me and any staff that might have involved. Nobody knows it's there. This child was 10 minutes from the border. That would have been the opportunity, if the mother had knowledge, for the mother to have removed the child. So that didn't happen. It was, and the benefit, so the child was reunited on a Friday. The father and his mother left their passports with the sheriff's department, and the judge had modified my warrant to allow the father to stay in Berrien County because Cass County doesn't have much in the way of hotels or motels. Then the judge allowed the mother a couple days to find a lawyer, and then we went to court. From my Traverse City office, it's a 5.5-hour drive to Cass County. So I got there, and I have a habit. I bring a soft, tactile blanket for children, because I find that it is very comforting for them to have this. I buy a lot of them. Some are baby blankets and some are small kid blankets. And then went in, had the hearing, and I asked the opposing counsel, does your client have any defenses? He hadn't filed anything yet. Is she alleging any defenses to this removal? And he said no. I mean, the mother was actually at a disadvantage in that there was no lot of time, but these cases are supposed to proceed quickly.
Right. And we're going to come back. I want to get into the defenses a little bit, but I want you to finish your story. But then we are going to talk about the defenses a little bit more before we finish up today. And also we have a question from the audience I want to make sure we have time to ask.
Okay, good. The defenses are that the petitioner is not telling the truth when the petitioner says that say Michigan is the habitual residence. of the child or the United States and the state of Michigan. The other defenses are that they had an agreement that works in some courts, but not typically here.
Okay.
And the another defense is that the child is habituated, has lived long enough in the place where found, that the child has become habituated. Another defense is that the left behind parent consented to the taking or acquiesced, just sat on his hands and didn't do anything. Or the petition,
Okay.
and by petition, I mean the papers that are filed in court. I don't mean the papers that are called for return, filed with the central authority. The actual filing in court must be made within 1 year or less of the taking
The Hague Convention filing, you mean?
Yes, exactly.
And then you mentioned a couple other defenses, and I think they were also mentioned in the Manaski case. One of them was the child's intent to remain in the new country was coerced or involuntary.
That defense has been raised in the case I had before Judge Neff. And I knew that from the father and what he had been able to determine just based on what had been said to him in the few telephone calls he'd been allowed with his daughter, that the child was going to say she did not want to return. And so the defense is a reasonable refusal to return. And that would be a case in which the judge would be required to interview the child and make a determination whether the child was mature enough to express an opinion and whether that opinion was in fact the child's opinion or whether it had been coerced.
Oh, wow. Another defense you had mentioned was that there would be a grave risk that the child's return would expose a child to physical or psychological harm or otherwise place the child in an intolerable situation. That was one that was mentioned in the Manaski case as well.
Right. That's often brought up because I think there are many parties. I mean, we see it in custody cases too. Many parties think that an allegation of domestic violence is going to do it for them. So it's not unusual. However, the UCCJEA has some tools that the Hague Court can use to formulate ways to protect the child. And so anticipating that, my packet of Article 13 materials would also include an affidavit from a lawyer who practices in neglect abuse cases saying, we have the resources in this jurisdiction to handle any possible domestic violence. And so, when you're talking about an older child, if the child is old enough to express and in school, so the child may express, yes, I've been beaten or sexually abused or in other ways abused, or psychologically abused, the court would of course file a 1300 and protective services would get involved. And, I'd hate to be that parent who had said, no, nothing like that is ever going to happen. Because then the court would change custody. And if the child changed custody, if the court changed custody, the court could also allow the parent to relocate back to the country.
So speaking of abuse, I hear of a lot of cases where the parent is alleging that they're the victim of domestic violence. But that sounds like that's not actually the test. It's about whether the child is or has the potential to be a victim of domestic violence.
That is not the test. The name of that case is something versus Tesson. And I think it's out of Wisconsin or Minnesota, someplace like that. And the mother stated that she was fearful of having the children be returned to Mexico because she was afraid that the father would abuse them. And she was afraid that she would be abused. And the court determined that there were resources available in Mexico, which was the children's habitual residence. So the children could be protected, and the mother would have her choice. She could opt to go, or she could opt to stay away. Hard result, but it is the way it is.
So one of the questions from the audience is about this person is Tracy Rink. She's a former chair of the family law section. Glad you could be with us today, Tracy. She does the UCCJEA registration and coordination in Oakland County. She works with law enforcement officials and the county district attorney's office to assist with picking up a child that had been wrongfully removed. So she wanted to know if other jurisdictions provide this service. And by jurisdictions, I think she means other counties in Michigan, but
I hear so often that parents are saying that the police won't help them. And I think that is true. I have experienced that. I have formulated a way to eliminate that avenue, and that is my warrants don't say you are ordered to enter the residence located at blah 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 on Front Street in Traverse City, for example, and remove a child or children and bring them back to the police station to be reunited with the other parent. My warrants say you are commanded to do this. What is the difference? Michigan has a governmental immunity statute. And under that statute, before it was amended a few years ago, if an act were discretionary, which is you are ordered to, that gives some degree of discretion. If the warrant says you are commanded to, there's no room for discretion there. And so I have found no problem getting.
So you get a warrant from the judge.
I do.
Right?
Yes,
okay. Not just an order.
I get
it's a special kind of order. So not on Hague cases, but the problem I've run into is with the pickup order is when I get an opinion or an order from the Court of Appeals that would enable us to go get a child, the police, the sheriffs don't want to enforce it because it's we don't get like we can't get the certified necessarily at the same time. We get things emailed to us or they're electronic from the Court of Appeals. So that doesn't have the stamp thing, right? The raised thing, but also trying to get the correct pickup language in there. And it sounds like the language you're using is you're commanded to, you include you're commanded to go to this residence to pick up the child.
Right. That's right. I had a similar kind of experience in speaking about the lack of seals. And I've never had that problem. So this would be my recommendation in a situation like that. I needed some, in a case involving custody, a motion to modify custody in a Michigan court over in the Thumb. The children were there for the summer. They came and they said that their mother had tried to commit suicide on an Army base in, I think it was Oklahoma. I got the phone number for the Army base. I asked for the FOIA officer. She was extremely nice. And I sent her a FOIA request. And she got it. She looked it over and she said, I am going to have to send this over to legal to ask them how much of what you're asking for I can give you. You may get reports. This would be ambulance reports, EMT reports, police reports, maybe some information. Tracy.
Everybody can't see that, so they don't know why we're laughing.
Anyway, you may get some reports and they may have redactions. And yes, I got reports. Well, so she said, call me. Or maybe she called me and said, the reports are ready. Yes, they're redacted. I have read them. Now, we could wait another week and you could, or 10 days or 2 weeks, and you could file a motion and ask for them to be unredacted. But she said, you know, the redactions don't matter. You're going to have enough here. Confidentially.
Yeah.
I don't.
Yeah.
Anyway, because this was a horrifying experience for these young girls to find their mother passed out on a bed surrounded by empty pill bottles. Mark Sullivan asked how I got records FOIA'd.
And just so you know, everybody knows, Mark Sullivan is the military family law guru, right? I mean, is that the same person?
This is the same person.
Yeah. So you taught him something? That's pretty impressive.
and I regret to say I promised him that I would write an article that he could put on his blog about how I did it, and I didn't do it. Let me say this: work-life balance. I am encouraging everybody who's sitting out there listening to me to look at the wrinkles on my face. Behind me is a walker. When I'm sitting 18 hours a day to 20 hours a day, one time 26 hours, that was in the Cass County one, 26 hours before I went to bed. It's not good for your body. And if I had it to do over again, I wish somebody had said work-life balance to me 15 years ago.
Yeah. So looks like our time is up. I wanted to, Jeanne, thank you so much. This has been so informative, and thank you. We had a lot of friends in the audience today, and for the people who signed up and got called into court and couldn't make it, we do have a recording. We will be sending out some materials for everybody. And there weren't as many questions as normal today, is probably because Hague Convention cases are so specific. But if you do have a question, go ahead and throw me an email. I'll make sure that Jeanne and I talk about it and get it back to you directly or as part of our materials that we'll be sending out sometime next week. And thank you so much to everybody for joining us today. Jeanne, do you have any closing words you want to say?
I do. I will be sending Liisa a lot of good materials, click through materials, so that identify, this is what you send to the judge, this is where you find it, and this is why you want to send it. Judge Roberts in federal court, Eastern District, she made use of those materials. Judge Neff did, and it's just invaluable. Judges who really care about these cases, they're willing to go the extra mile for them.
Yeah, good. So yeah, don't overwork yourself like I know Jeanne has. I think she needed an assistant every time she had one of these cases walk in her door because they were very time consuming, but extremely worthwhile. I can tell that.
You know, everyone's different, so it's not like I get to use all the things that I usually
No,
do.
I know you don't. All right. Well, thank you, everybody. I'm going to close this out now and look for something from us next week.